Good morning. My name is Martin Kenney. I'm from the British Virgin Islands, and I'm here to moderate a panel styled, If an Offshore Investment Fails, Who to Sue, Where to Sue, and What to Sue About. Today, we have three panel members, delightful ladies, Felicity Toube, who is a barrister in London, who does a substantial amount of work in the offshore sphere, in the English-speaking jurisdictions offshore, in order to attempt to recover value precisely through bringing actions of the kind that we're going to be describing or discussing this morning. Also, we have with us right next to Felicity is Maureen Ward, who's a partner at Bennett Jones in Toronto, that in my view has the leading fraud and asset recovery practice or subspecialty practice in Canada. Bennett Jones, I know, was rooted in Alberta, was an energy firm, oil and gas firm, but has since branched out now with a substantial practice in Toronto, in central Canada. We also have Anne Gittleman at the far end of the table on my right. Anne is with Kinetic Partners in New York. She's a certified insolvency restructuring advisor, a certified public accountant, and a certified fraud examiner, an expert witness in the area of forensic accounting, specifically in the area we're talking about here today, which is what do we do to try and recover value for creditors or possibly victims of an offshore investment scheme that fails. Now, to clarify, when we're talking about failure, we're not talking about, today at least, restructuring, reorganization, or attempting to rehabilitate an enterprise that fails. We're talking about liquidation, complete disaster, where all has been lost, apparently with some perhaps residual amount of value to work with in terms of investigation and recovery. Yesterday we had a panel session on trying to locate and recover concealed assets, hidden assets. Some of the techniques used that we're going to describe in this panel overlap with yesterday, but there's a big distinction between the two panels in terms of our purposes. Yesterday was really about recovering the hard assets side of the house. Today it's more of the soft side of recovery, meaning intangible, inchoate third-party claims. Who to sue for damages or compensation, in contrast to recovering yachts, boats, houses, and what have you. Now, with that introduction, let's see. The first slide, who to sue, likely cast of characters. And I'd invite you to give us a few observations on this.
I'm going to just speak about the likely cast of characters. Oh, microphone, sorry. Hopefully you can hear me. The likely cast of characters in a failed investment scheme will often, as you know, include directors or shareholders. So if your investigation determines that their acts or omissions warrant an action and or scrutiny by the court, there are a variety of causes of actions that can be pursued, and they will no doubt require the piercing of the corporate veil and perhaps even a clawback claim or a look at potential derivative payments that may have been made. The details of establishing the cause of action it will be discussed shortly in this presentation, but these two top the list, if you will, of a review of the likely cast of characters. Thirdly, you'll see on our slide that in the case of banks, and this is, I find, something relatively unique over the last 10 years or so, that you can look to the bank to see if an action is warranted on several fronts. And this can include actions as a customer and in some cases as a non-customer of the bank. And those causes of action that we'll discuss shortly can include knowing assistance, negligence, willful blindness, and the like.
And what about third-party transfers, fund managers, service providers?
So When you're going to look to pursue actions, you'd review third-party transfers. They're very important. You'd want to see if there's any abnormal flow of funds going in and out of bank accounts. Is there high frequency? Are there any large transfers that were made towards the end of the life of the fund? And from there, you dig a little deeper to see, okay, if it was a wire, who did it go to? And that could, give you some third parties that you'd want to pursue, either in, bankruptcy or liquidation proceedings through preference and clawback actions. You'd also want to look to the obvious, the fund manager, to see if he or she is complying with the terms of the PPM in their investment strategy, if they breach their fiduciary duties in any way. And also, you'd like to look to the service providers, such as the auditors, the fund administrators, and anybody else who assisted the fund, to see if they in any way assisted the fraud or were grossly negligent in not detecting some sort of wrongdoing.
Felicity, what about investigation of targets?
So now we know the kinds of claims that we might be bringing against the sort of people we might be bringing. But there's no point bringing the best and the easiest of claims against people who have no money. So the first thing you want to know is who's going to be good for the cash, who has deep pockets, who is going to be an easy target, are they in the right jurisdiction, can I get hold of them? We'll talk some more about this later, but if they're in the Middle East or Russia, they are not an easy target, and you should cross them off your list. Is there anybody who has hard assets? We're not really talking about this today, that was the panel yesterday, but is there cash in a bank account? Has someone got a house? Those are things that are easier to freeze, get, sell, depending on what jurisdiction they're in. And finally, the question of enforcement of any judgment will be key. You can get a great judgment in Cayman or BVI, but if you can't export it to where the person has their assets, you've been wasting your time. So before you spend your time and your money working out what causes of action you have, bringing them, investigating all the rest, work out if your targets are good for the cash.
Now, the next slide is captioned for what? Investigating potential causes of action, specifically how to frame and develop theories, core theories of liability and damages models. Maureen, what about piercing, or English lawyers say lifting the corporate veil? What do we mean by that?
Well, where a wrongdoer can no longer be protected by the limit of liability that that a company, and incorporating a company, can offer, their actions can then be exposed, and you can go after them personally. And you look at whether their actions are so egregious that an action can be warranted personally. Are they using the corporation as a sham? Or are they using it as a vehicle through which they can continue or to perpetrate their wrongdoing? And so in those circumstances, you ask the court to pierce the corporate veil to get behind the company and the incorporation and the protections that it affords in order to find some personal liability against directors and the like.
Just a question out of turn, Felicity. I think that English lawyers would look at the notion of piercing or lifting veils as a difficult idea, a challenge. Isn't it the case that in English-style litigation, for instance offshore, that we might want to frame actions that almost ignore the veil and sue directly on an agency principle or a breach of trust theory?
Yes, generally we don't like to lift the veil unless we absolutely have to, because as soon as you are saying that to any judge, particularly in offshore jurisdictions, you've lost. So you phrase it in a different way, and one of the things I'm going to come back to talking about later is whether or not you can get yourself in as shareholder to collapse companies' structures in that way. But I couldn't agree more. Piercing, lifting, all the rest of it, not very English friendly.
And this is an important distinction, although in Canada and the United States we speak the same language called English. In crucial areas like this, there is a big departure in terms of the judge's use of language to get access to remedy for victims in cases like this. And veil lifting or piercing is exactly that. In the United States, for instance, if there's lack of formality in the administration of a company, judges have jurisdiction to, quote, lift or pierce the veil. And we have no such principle in the BVI, in Cayman, Guernsey, Jersey, or England. Not at all. You can't say to a judge, oh, they didn't fill out the forms properly, or hold formal meetings, or have proper books and records, and lack of formality gives rise to the right to ignore the corporate veil of the relationship between protecting personal capital and company capital. We don't have that at all, even though we're supposed to be close cousin legal systems. Now, Anne, I'd ask you to direct our attention to fraud claims, including against third parties. What do we mean by that?
Well, fraud claims are, the most, I guess, prominent out there that people have, heard of claims being brought against various parties for fraud. One thing that I would like to highlight, though, is there is a heightened pleading standard to bring these types of claims. So they're extremely difficult. You have to plead your case with particularity, which means you have to give a lot of detail of the facts that lay out the fraud. And so it becomes problematic or harder to bring as a plaintiff against third parties in lawsuits against them. So you may want to look at one of the other causes of action that we're going to discuss later. However, if you do have the facts that are good for you and think you can move the case forward, then it could be advantageous to bring a fraud claim.
We won't digress too far afield from the agenda, but fraud claims, Felicity, I find the tort of deceit, which is a very narrow, complex tort of misrepresentation by deceit, to be tricky, difficult, and awkward in this area.
Yes, so in England we refer to fraud as the F word, and we try not to use it unless we absolutely have to. So fraudulent misrepresentation, deceit, and fraudulent trading claims, tricky to bring, very few in case law that are actually successful. But if you've got the facts for them, then there are the right cases to plead them.
So the first two bullet points, the thesis would be North American style litigation on veil lifting or fraud is very different from what we do offshore in the English common law system. We steer away from the first two bullet points, and we like to get into agency law and breach of fiduciary duty. Aiding and abetting liability. Maureen, what is this?
So these are actions that can be brought against individuals or companies that have participated in some way in allowing the wrongdoing to occur. The tort of knowing assistance is developing in Canada, and it's where, funds that are subject to a trust in favor of the plaintiff is somehow taken in breach of trust, and you can establish a link that the defendant participated in and had actual knowledge of the trustee's dishonest and fraudulent conduct. So in Canada, the courts have held that the actual knowledge part of that test can include willful blindness. And so how do you establish willful blindness? Then you look at whether or not there are facts that would put a reasonable person on inquiry, and they failed to inquire or take any action to prevent the fraud in a timely fashion. That will be a relevant consideration of the court in determining whether or not there's liability for knowing assistance in the fraud.
Maureen, an English lawyer might say that if a banker falls below the standard expected of an honest man or woman in his or her shoes, that might cross the finish line in terms of some form of liability in this area. Falling below the standard expected of an honest person or banker. Would Canadian judges use the same language?
They're slightly different in that they look at a reasonable banker and a reasonable person giving consideration, for example, if the action lies against the bank for knowing assistance, they look at what is the reasonable standard at the time, what was the industry standard, and was that followed? And this, of course, includes anti-money laundering compliance regulations and procedures, and also know your client, know your customer due diligence.
In England, we have the same theory. It's called stages 1 to 3 on the Baden-Delvaux scale, which makes it absolutely clear. We all know what we're talking about now. It has to be some form of unconscionability, which, of course, makes it even clearer. So the case law is sliding all over the place. We used to think that knowing assistance was a strict liability claim, and so we didn't have to show any kind of anything. But the House of Lords, as it then was, in their wisdom, have chosen to disagree with those of us who are sensible on this point. And so until we can get that changed, we're in this unconscionability, touchy-feely field.
Gross negligence, and from an American perspective, what's your understanding of these claims?
Gross negligence claims are, once again, another rung down, are easier to bring in the U.S., and also kind of lump in the breach of fiduciary duty claims into this section as well. So you're basically acting in a manner that is reckless or with complete disregard. So it's not mere negligence, but it's something above that. And this has a much lesser pleading standard to bring those cases. So plaintiffs, if you do have the option to do that, it is a good cause of action to look for.
And do you find that the reason we talk about gross negligence instead of suing in mere negligence is that many banks impose restrictions on their liability contractually with their customers, right?
Correct. Yeah.
And so the banker's form might say, I have no responsibility to you, my customer, save unless I'm grossly negligent or have committed some willful act of breach.
That is correct, yes.
Okay. Now, Felicity, would you agree with me that in 1960s, 70s, 80s, and perhaps some of the 90s, English judges would look at this phrase, gross negligence, they say, well, this is an American curiosity, this is really just negligence. But now things have changed and the legal systems seem to be merging on this concept. I've seen English judges talk about the notion that, well, it's something more than mere negligence, but I have not seen an English judge say it's recklessness. Have you?
No, it's, again, the helpful guidance is it has to be gross. So that makes it clear it's something more, but what it is, you'll know it when you see it.
But not reckless. Recklessness to us means something, a complete willful dereliction of responsibility. And I don't think we're there yet in having to establish that with gross negligence cases.
Just in case you want to know, that's numbers 4 and 5 on the Baden-Delvaux scale. So anyone who wants to read 19th century law and work out what that scale might be, it'll all become clear.
Maureen, constructive trusts.
So often a common adjunct to a claim of the causes of action we've discussed, including fraud, can include a claim in constructive trust against the wrongdoer, but more importantly against those who hold assets in trust, if you will, for the true owner, the plaintiff. So the concept is that the parties hold these funds in trust for the true owner, and often in cases in Canada we include, for example, inevitably there's a spouse who does not work and who holds a large mansion and all kinds of money in their bank account, and certainly we sue them in constructive trust on the basis that they hold that money in trust for the plaintiff.
Now this, I recall in 1982 in law school in Canada, constructive trust as a cause of action was developed from a famous family law case by the Supreme Court of Canada. And I don't recall ever seeing an English judge refer to the remedial constructive trust. So this is another example of a complete departure between Canada, which is supposed to be a part of the English common law, at least 9 of our 10 provinces. Felicity, what about constructive trust as a notion in England?
We don't believe in remedial constructive trusts.
Well, what is that?
But we do often give constructive trusts as a remedy where it might not be obvious that it actually was a trustee sort of trust. So judges will say all the time that they don't believe in constructive trusts as remedial constructive trusts. But it is used sometimes as a restitutionary remedy. It's used sometimes by way of subrogation. We do sometimes get it as an alternative to going through substantive consolidation or something like that, which again we don't have in our jurisdiction. But we can use constructive trust type concepts to get to the same position.
Now, we're going to ask Felicity to review suing in the context of insolvency and bankruptcy claims and actions to obtain property.
Much as I'd love to spend the whole hour talking about this, I thought I'd just give you some headline points. We're going to talk in a moment about the insolvency and bankruptcy tools that we can use, but for the moment, just talking about the claims, we're looking at antecedent transaction claims. We can look at setting aside floating charges. We can look at disqualifying directors, which can be used as a way of stopping directors doing the same thing again. We can look at wrongful trading, which is not putting a company into insolvent liquidation when you knew or ought to have known that it couldn't avoid going into it. We can look at fraudulent trading, which is assisting the company continue in a way that was fraudulent or for any fraudulent purpose, whatever that might mean. And we can use any of the normal procedures on top of that. So the real area in which you're going to have something completely new will be the antecedent transactions, which will take you between 6 and 2 years back, and will, depending on what country you're suing, will either require some kind of fraudulent purpose or will require an intent or a desire to do something, which is way short of that. There are, of course, also breach of duty, negligence, misfeasance claims, which are often codified, but aren't really any different from the common law. So those are the insolvency and bankruptcy claims in the UK and the Commonwealth. Actions to obtain property. This is what I was talking about earlier. If you come in as an office holder, a trustee in bankruptcy, or a liquidator or an administrator, you can use your powers to stand in the shoes of the company that you're coming into in order to do whatever that company could have done. So if you are a parent who has the right to do things as shareholder, you can use that to collapse down structures in circumstances where you don't want to go anywhere near piercing or lifting the corporate veil. And I did that in one case. I had a timeshare fraud going on in Spain, and it was held through 180 different companies worldwide. And I didn't want to go anywhere near trying to lift the veil, although my submissions did start. This is a company that was held through, all the assets were held through this network, and I held up a large thing. Looks like a web, and the spider sitting in the middle of the web was the fraudster. And if I tell you the jurisdictions of which these companies were incorporated, that might make you think there was something dodgy going on, to which the judge said, unless it was for perfectly genuine tax purposes. So I thought that was probably the point at which I should stop talking about piercing the veil, and I just substituted myself as shareholders and collapsed down the structure from the top down.
Thank you. Before we move to the next slide, I think one point that comes through each of these bullet points in our discussion is that we are faced with vexing conflict of laws issues in each of these cross-border insolvency fraud cases. So if we have a hedge fund in BVI or Cayman that collapses in a heap, and we have management back home in New York, an auditor in Chicago who may be subject to Illinois standards for negligence, and yet the injury or the loss sustained in Cayman or BVI. We have different SOL issues, statute of limitations. Offshore could be 6 years generally from when the cause of action accrued, and sometimes if there's been concealment, we get an extension on the 6 years, whereas in America generally statute of limitations is much shorter, 2 years for negligence, sometimes less, sometimes more, and we find ourselves trying to figure out what the best legal system is for bringing the claims for SOL, statute of limitations, and substantive legal purposes, which gives rise to the need to have a team of professionals from each of these locations to figure out what's the best construction in the architecture of the claim to maximize recovery, because as you can see, we have very different approaches, even though we're supposed to have the same language. Moving now to the next slide. For what continued investigation tools, Felicity, data preservation.
Yeah, I put in a bid for data preservation as a subject because you would think it would be obvious that one of the first things you would do would be to go in and preserve data. One of the most surprising things I have come across in recent years was in the Stanford case, where, as you probably know, there was a difference of opinion between the Antiguan liquidators, or as I like to refer to them, the bad guys, and the U.S. receiver, who was my client, who I like to refer to as the good guys. Others may hold strangely different views on this. The former liquidators, yes, the former liquidators.
The present team is at the table.
Yes, the present team we love, the former team not so much. And the former team, I make that absolutely clear, went into Canada and found the data server in Canada and copied it, no problem there, wiped it, big problem there, refused to cooperate with a Canadian regulator, very odd behavior, and then were quite surprised when they weren't recognized in Canada as being the people who had a right to deal with this. So, yes, they wiped it, they took everything out of the jurisdiction. So, you know, preserve your data, but also don't annoy the regulators. That's just a number one rule for what you're going to do. So data preservation, pretty obvious, but when it goes wrong, it really goes wrong.
I know something about that case, as we removed them from office for precisely the wrongdoing that Felicity outlined, but it was worse. There were 5 hard drives in Montreal. They imaged 2 of them and wiped clean all 5, so there are 3 hard drives. We have no idea what data was on those hard drives. And witness research and interviews, forensic imaging, analysis.
Well, those are 2 very important areas when you're performing an investigation to determine what happened, who to sue, and for what causes of action. Witness research and interviews are key. You want to get in there as soon as, you know, fraud or gross negligence or something comes up on the radar that something has gone wrong, because witnesses' recollection grows vaguer as the time continues. So you want to get in there as early as possible and interview them in a formal process where you go through, you know, what happened, who was involved in any alleged fraud, and how did he or she carry it out. So this can be extremely time-consuming. I was involved on this one matter where, you know, there was an accounting fraud that was alleged, and, you know, being brought in much earlier rather than later is very helpful for bringing actions, because the evidence is still there and present, and people's memories are fresh. And, you know, it could be, you know, an all-day, all-week type of thing, depending on how many employees are with the company, but extremely helpful as an investigation tool. Forensic imaging and forensic analysis, once again, is extremely important when assessing claims. You really want to go in and copy all of the hard drives, make another copy, and copy them in an orderly fashion, because what tends to happen is after, you know, the company gets turned upside down on its head, so do the documents. And so it's really hard trying to piece them back together. So if you get in there earlier rather than later, you can, you know, copy all the drives, the folders in some orderly format that you can bring back to analyze. And forensic analysis is key because, once again, it helps the party determine who is at fault here. You need forensics to come in and somewhat trace the money to see what happened, where it went. Company just doesn't lose $1 billion overnight. It has to go somewhere. And so that's where forensic review becomes extremely important.
Maureen, I'm going to ask you to talk very briefly about search orders and disclosure orders, as we did cover these items yesterday in finding hidden assets.
Certainly. So briefly, the Anton Pillar order in Canada has been described by the courts as the most powerful weapon held in the court's arsenal. It's often referred to as a civil search warrant. Certainly there are several safeguards built into an Anton Pillar order, but essentially it orders a defendant to allow entry into his or her home, place of business, even the trunk of a car, for the purposes of the plaintiffs searching for and removing evidence. And certainly that evidence has to be laid out with specific particularity as best as possible in the order. Often the courts in Canada previously did not require an independent supervising solicitor to be there because Anton Pillar orders have such a big potential to go sideways. It's now a requirement to have an independent supervising solicitor there to help interpret the order for the defendant and deal with any claims of privilege. Enough about Anton Pillar orders. The disclosure from third parties, Norwich Pharmacol and Bankers Trust order. Again, that was dealt with extensively yesterday, and I'll simply say that it's such an incredible tool that can be used particularly without notice in advance of an Anton Pillar order or Mareva injunction, so that when you go to use the Mareva or the Anton Pillar order, you've secretly done all of this great work with the use of the Norwich Pharmacol order, and you've been able to review bank accounts, so you can cast the net wide, if you will, in respect of bank accounts for Mareva and in respective locations for an Anton Pillar.
Thank you. Felicity, criminal powers and insolvency investigative powers in the Commonwealth and the UK.
Criminal powers I'm going to deal with quite quickly. I try not to get involved with any criminal powers unless I absolutely have to. Once you get the criminal authorities involved, you are into deadlock often. Things get tied up in horrible bureaucracy for more time than you would like. But there are some criminal powers which are really very vital. There are things that the criminal authorities can get access to which you are never going to get. And so there are circumstances in which you would like to have the help even of the Serious Fraud Office because they have very good weapons in their arsenal which you can't get hold of. Insolvency powers is much more obvious. We can investigate, we can exercise our own search and seizure orders without any supervising solicitor needing to be there. We can stand in the shoes of the bankrupt person or of the liquidated company, and we can waive any rights to privilege. So in other words, you can get hold of any documents from solicitors, from banks, and all the rest of it. And so those powers are going to be inevitably the most important to you.
I would just add, Felicity, I agree completely with your observations of the flaws of dealing with the criminal powers in the English-speaking world. But Ed Davis pointed out yesterday that we're in Central America, South America, Switzerland, the continental European legal systems. We want to, on behalf of the victim, crawl into the criminal system as a partie civile, as a party with standing in the case in a money laundering investigation to gain access to information, because civil litigation and discovery powers in that sphere are very, very poor. So in the one sense, in the English-speaking world, Felicity is absolutely correct. The criminal authorities are a disaster in terms of cooperating with victims' rights. But in another sense, when we have cross-border cases, we have to sew together civil litigation on our side of the house, English-speaking, with some form of criminal investigation in the civil area.
The only thing I would add to that is that in some jurisdictions, like in Spain and in France, you have a real problem once the criminal authorities do get involved, because they find it difficult to understand that the people who are victims of the fraud are the same people who are creditors of the fraudster. And so persuading them actually to hand anything over to you can be a difficulty. So they have the powers, but sometimes they like to hold on to the assets.
Now, Anne, what about U.S. bankruptcy powers of investigation?
So similar to what Felicity said about the UK insolvency powers, you have great investigatory powers under U.S. bankruptcy law through 2004 subpoenas. And these subpoenas allow the trustee to send out information seeking subpoenas and request documents. So unlike most cases in the U.S., if it's brought in federal court, you usually cannot obtain discovery until after the motion to dismiss is decided. In bankruptcy, it's very different, where no action has to be commenced, and these subpoenas are very powerful, where the bankruptcy trustee can get whatever type of documents he or she wants to review to determine if anybody is at fault in that instance.
Maureen, what about in Canada, bankruptcy investigations?
Again, very similar. The trustee, pursuant to Section 163 of the Bankruptcy and Insolvency Act, can examine and compel sworn testimony under oath of anyone reasonably thought to have knowledge of the affairs of the bankrupt, or anyone who was agent for the bankrupt. And that evidence shall be filed with the court. Interestingly, the deemed undertaking rule, I think in the UK, applies to such evidence, but in Canada, there's a body of case law suggesting that a creditor can later on use the testimony given by parties other than the bankrupt to support a subsequent civil case. So it's great sometimes to build on the powers of the trustee as a potential litigant. So again, broad powers that are quite similar, I think, to the UK and the US.
Before we move on, I'll just note that we didn't cover defenses, extirpe causa in the English system, in peri delicto in the American system. These are problems that give rise to when we bring claims to the auspices of a perhaps fraudulently managed fund or company. Defendants point out that there may be a legal problem in having a party that committed unlawful activity, in theory, acting as claimant, and that may deprive the ultimate parties in interest, the creditors, the victims, of access to justice using these technical defenses. Another problem I see over and over again now is in these very complex multi-entity fraud or fund cases that collapse offshore and on, like Stanford. The American receivers, like SEC receivers, have a very different approach to the English liquidation and claim framing process. And the big stark difference is the American style is to put everything, as Judge Godbee said in Stanford and Dallas, into a black box to simplify the process. So an SEC receiver may be appointed over Mr. Stanford's assets and affairs, as well as an array of his corporations. And then all of a sudden we have this claimant platform, which from an English perspective is very odd. It's hard to understand what it is, because the receiver is now suing for and on behalf of Mr. Stanford and all these other vehicles, but he wants to now bring actions against law firms, investigation practices, auditors, and what have you, who have no privity with much of the black box. And so that can give rise to fractious problems on just basic standing, locus, and privity issues, whereas in the English system, our judges just can't cope with that. They need to have a clear relationship, if you're going to sue an auditor, between the company and the auditor. And somehow we need to work better in harmonizing these different approaches, because otherwise third-party claims in our system can be demolished by virtue of the use of the black box, which SEC receivers have a tendency to like to use. Now let's move to the next slide. Where to sue? I invite, please, Maureen to introduce this subject and the notion of forum nonconvenience.
So it's trite to say that where to sue is probably one of the biggest questions that you consider. First, the first top three considerations on where to sue would be jurisdiction. is there sufficient facts for a court to ground jurisdiction with respect to your cause of action? Are you going to bring other actions in other jurisdictions, and how might that, what is the interplay? Secondly, in determining what jurisdiction, you have to look at your limitation periods. As Martin said, the limitation periods vary from jurisdiction to jurisdiction quite surprisingly in number. Even within Canada, each province has their own limitation period that can vary anywhere from 2 years in Ontario to 6 years. In addition, in Canada, all the provinces the courts can rely on each other's case law. However, there's an exception with respect to Quebec in certain circumstances because they have their own civil code. So you have to look at what causes of actions will fly, if you will, in the jurisdiction that you choose. And then just quickly touching on forum nonconveniens, you look at, if a court has taken jurisdiction, you, as a plaintiff, can also be subject to arguments that, notwithstanding that you have jurisdiction, there is a better forum. And to be clear, the test is not, for forum nonconvenience, is not, oh, this forum is going to be better. You have to determine if the other forum is clearly the better forum. And the court can look at a whole host of factors, including the location of witnesses and parties, the existence of contracts and whether there's a jurisdiction clause in the contract, the location of the evidence, and those types of considerations.
Felicity, primary and secondary legal proceedings, anti-suit.
Just before I turn to the question of primary and secondary legal proceedings, your first question may be, if you're in a formal insolvency process, what country do you want to have that insolvency process in to start off with? Generally, on a cross-border basis, that's now determined by working out where your center of main interest is, where do third parties, where is it ascertainable that you were carrying on your business, to where do you have your connections, where's your head office, where was it being run? And that isn't always a straightforward question. Stanford's another example. Antiguan court says the center of main interest is in Antigua. The U.S. court says it's in the
The center of main interest of the black box,
of the black box.
not of Stanford Bank.
Right. So the center of main interest of the black box with all the assets in it is the U.S. Switzerland is
The Comey is in Antigua.
Is in Antigua.
UK.
Canada is in the U.S. UK, or one of the entities, is in Antigua. Everything else is in the U.S. So it can cause a problem because you might have thought we were all thinking about the same entity, but depending on which court you ask, it has its center of main interest somewhere else. And whether you have primary or secondary proceedings, insolvency proceedings, is very important to working out whose law governs where you can go and who can make those decisions. So that's going to be important. But then you'll have primary and secondary legal proceedings within that. You might have a BVI liquidation, but you might want to carry on some proceedings in the US. For example, one of the elephants in the room we haven't mentioned yet is the BVI and Cayman indemnities. There was a whole panel on those yesterday, so I won't bore you with them, but the thought that you can get an indemnity against fraud and willful default and gross negligence and anything else you like, both as a matter of law and as a matter of contract, is surprising to other jurisdictions. So depending on whose side you're on, you might either want to be in those jurisdictions or not be in those jurisdictions. Anti-suit injunctions is the flip side of that. Once you've decided where you want to be, you try and get an injunction to stop it being in the place you don't want to be. And I can't emphasize enough how important it is to have a cross-border plan and have good teams who will advise you on that. So forget limitation periods. Indemnity is usually the killer.
Now we move to identifying the relevant jurisdictions, perhaps in a global map. We then separate them into good and bad places to litigate or investigate in. And what about the United States, the approach? Then I'll ask Maureen for Canada and Felicity, England.
Great, thanks. The U.S., there's a lot of good and bad qualities to bringing litigations there. One of the pros is that there's no adverse legal cost awarded if your case is dismissed, unlike that of a Commonwealth jurisdiction where you have that problem. So you do have a lot of, litigation that's brought there. One potential problem or problems that have been seen is that there is a delay in the court system because it is a good area to bring cases. The courts are completely flooded and judges have a difficult time rendering decisions in appropriate manner. For example, a case that I am working on involves the Petters fraud out of Minnesota. And for those not familiar, the Petters fraud was a $3.5 billion Ponzi scheme. And probably the biggest case that a Minnesota bankruptcy judge will ever see in his lifetime. And as such, there are a lot of different issues that have arose. The case is multifaceted, and there is a very important decision that the judge has been sitting on for almost 2 years and hasn't rendered a decision yet. So that's definitely one of the problems that you do have in the U.S.
Maureen, Canada.
Hopefully I won't sound biased, but I'll start off, Martin, with a few things that I think are good in respect of litigating in Canada, followed by one bad point. But maybe you can jump in after. But first, with the Moravian injunction, I thought it would be topical to discuss a couple of developments in that area in Canada. First of all, it was difficult, when I started practicing. The test for the Moravian injunction required actual evidence of a risk of dissipation. It required evidence of dissipation. We convinced the court at some point, I think I was in my second year, we managed to convince the court that, Your Honor, all of the conduct that this person has done is so egregious and fraudulent and so obvious on a strong prima facie case that you can infer the risk of dissipation. You don't need us to show you a plane ticket that we found in his desk. And the court agreed. And that area has developed for us, and it's been very useful in terms of case law for the Moravian injunction. Secondly, courts have ordered an affidavit be delivered by the defendant of a Moravian injunction, setting out the nature and location of their assets. And that's a great adjunct to a Moravian injunction that I don't know if it's the same in the UK.
It is.
Oh, excellent.
That's where it came from.
So we have that. And then thirdly, and unrelated to the injunction, the courts in Canada have looked at Ponzi schemes as what they view it as is a Ponzi scheme is actually insolvent upon its inception if it's a true Ponzi fraud. And accordingly, clawback claims can be treated in the same way that a preferred creditor can be treated in the bankruptcy arena. So that's been useful as well. And then one more point is, I was reminded earlier when we were talking about fraud claims, and Felicity called it the F word, but sometimes, especially in our fraud cases, we do want to use the F word because if a judgment is rendered later in a civil fraud case and it references fraud, that judgment will survive bankruptcy pursuant to Section 178 of the Bankruptcy and Insolvency Act. So if you have a case where you haven't located the assets, but you're pretty sure there's a pool of assets somewhere, you can hang on to that judgment for quite some time and execute later on because it will always survive any potential bankruptcy.
England, Felicity.
I'll do this quite quickly because obviously England is the best jurisdiction. And
Isn't it rather expensive? Your fees are a little more expensive there than in other places, in sterling, too.
Our fees are entirely reasonable. Yes. Well, the biggest problem about the UK is adverse costs orders. There's no question about that. The other problem with it is that we don't generally have assigned judges. So you as clients will say, well, can't you just call up the judge? And I'll say, there is no the judge. There is a whole bunch of judges. And security for costs. If you're an insolvent company, it's possible to require you to put up money up front or a bond. Less common, but possible. The plus sides, though, are, and some people may disagree that these are pluses, but I feel quite strongly that they are. First of all, that your hearings are oral hearings. Although we put in written briefs, our hearings are still done orally, which means that there is a chance, actually, to see whether the judge has got it wrong before you see his ruling. The second thing is that we don't have juries. That makes it more predictable. We have very high-quality judges in the UK, and increasingly high quality across the Commonwealth. There was a time where that was an issue, but there are now much better quality judges in other Commonwealth jurisdictions, Caribbean in particular. And the other thing is that in terms of delaying judgments, in the UK at least, if your judgment takes more than 3 months to come out, you will be censured publicly. So judges have a 3-month time limit to get their judgments out, and they do generally do it.
That time limit doesn't exist in Canada, and that's one of the problems, certainly, is the time it takes for a judgment to be rendered by certain judges.
We have the same issue in the Caribbean, except Justice Bannister in our commercial court fires them off in 2 weeks from a hearing. And what about likely jurisdictions for monies? We have Russia, Cyprus.
Yeah, so another factor that you should look to decide where to sue is where are the likely jurisdictions that money was funneled or pushed off to. So if you know, Russians in Cyprus is one example. Clearly you've heard money, being funneled to offshore jurisdictions such as the Cayman Islands and BVIs. So definitely something to look to. You don't know, though, off the bat where monies will be funneled to. I was recently involved in a matter, and monies, it was a U.S. citizen in the U.S., and monies were being funneled to Brazil. So it's something that you really have to look at through your investigation.
Now, we're now moving on to Felicity with enforcement.
I'm going to deal with this quite quickly, which is a shame, but we're starting to run out of time. This is going to be one of the most important questions. We flagged it up at the front. We've identified there some of what I call the friendly jurisdictions, by which I mean it's fairly easy to enforce through them. Canada obviously should be included in that list. Sorry for that. Tricky jurisdictions. Tricky was the politest word I could think of for these. The Middle East and Eastern Europe. Very, very unpredictable. Sometimes impossible for foreign claimants to come in at all, not understanding what an insolvency is, not understanding why you might have any rights of any sort, getting local advice which actually tells you what the law is as opposed to what they think you might want the answer to be, and advice that stays the same throughout the case rather than changing on a daily basis. What I've identified as friendly but slow jurisdictions, much of Western Europe, I don't include Germany here, but France and Spain are a nightmare. You cannot list hearings in those jurisdictions. You literally take your docket and put it in the inbox of the judge, and then you send somebody to the court every day to say, has the judge read it? Has the judge read it? Has the judge read it? And then you wait for the judge to make a decision. Has the judge decided on it? Has the judge read it? Has the judge decided on it? And it is infuriating beyond belief, particularly when you are supposed to be automatically recognized in these jurisdictions, and some of them say, oh, you haven't made a recognition application. So Western Europe, inability to get court time in Greece, even before the collapse, was a problem. I remember one case in 2011 which got adjourned from January 2011 to January 2014, and that was just for somebody to put in some further papers. And when I asked whether that was a typo, apparently it wasn't. Limited availability of judges in the Caribbean. There is now so much going on in the Caribbean that it is very, very hard to get a court date. Recently in Cayman, a case that was in front of the Chief Justice, he did say that he would be happy to authorize a retired English judge to come in and hear it, or part of it. Now, of course, we can't find anyone who wants to go out to the Cayman for 2 months to hear a case. So that is, in terms of enforcement and practicalities there, really infuriating.
Moving further into practicalities, a crucial area, funding, litigation funders. Anne?
Litigation funders has become an increasingly high-profile topic. A lot of the times liquidators get appointed on funds that are completely stripped of all assets and just really left with litigation claims. And if you go back to 2008, there were kind of a select few parties out there that were doing this kind of one-off where they were funding litigations. Now there are, funds set up for this purpose in its entirety, where they just go around to liquidators and, various other people to see if there's an opportunity to fund a litigation because it has become extremely profitable. At least in the U.S., this is a very, I could talk about this for another hour just on litigation funding. I know in other jurisdictions it's a bit more problematic.
Right. We were discussing this earlier. In contrast, Canada, it's been noted in our own bar publications, is slow to follow the lead of the UK and the US in terms of litigation funding. There are a few funders. They certainly require the lawyer to almost guarantee that you're going to win, and you know how much lawyers don't like to do that. But I think that it will become more and more prevalent as time passes.
Felicity, what do we mean by insurance in the area of funding?
What I'm looking at here is what we need in England, which is adverse costs insurance. And so you can now get this. It costs a lot of money, but you can get it, and it is an alternative to litigation funding, which is also fairly well developed in England.
Although recently we were able to obtain an ATE policy which didn't require payment of any premium up front, and rather, I believe the premium equals 30% of the value of any cost award. And so if the plaintiff was successful, then the ATE insurer's premium would become due at 30% of the value of the cost award in favor of claimant, I think is how it's styled. And then we were required to post security for costs, and Master Moncaster of the High Court said, okay, he gave us credit of 85% of the security bill for the ATE policy, and we had to come up with 15% on the plaintiff's side in cash. So there's the insurance market in England seems to be flexible enough, in the right cases that are credible, to provide solutions on adverse cost risk management. Maureen, what about cash and liquidated assets?
Just very briefly, this is simply the concept of paying for your litigation with the resources that you have. Nothing more to say.
And building the team.
So at the beginning of a liquidation and, beginning of any litigation, you should, I can't emphasize this more, bring in your team. So that means your lawyers, your forensic accountants, your investigators, your computer forensic people, because you really need to have all these people in place early on as opposed to, later in the game.
Because of limited time, and because we covered the notions of freezing orders, gagging orders, and injunctions yesterday in the hidden assets panel, let's skip to the last subject, use of cross-border assistance, MLATs, mutual legal assistance treaties, enforcement of judgments, insolvency assistance, UNCITRAL, EC regulation. We'll break it down this way. Felicity, how can MLATs help us in providing access to justice to victims?
Again, I try and avoid MLATs unless I really have to go anywhere near them because of getting the criminal involvement of the criminal authorities. But that was used in Stanford. It did cause some problems. But it was used between the US and the UK with the Department of Justice making the request to the Serious Fraud Office, who then made the request to the courts. So it is a form just to be aware of. There are a lot of MLATs around.
Maureen, enforcement of judgments.
Quickly, before enforcement of judgments, as an alternative to MLAT, although it's a form of MLAT, is the use of the letters rogatory, which I find works quite effectively depending on the jurisdiction. And then the enforcement of judgments, first you look to whether there's a reciprocal enforcement of a judgment treaty, and then often, I think the same is the same as the UK, the court looks at basic factors before they will enforce. Is there comity? Is there an indication that the judgment was obtained by fraud? Does enforcing the judgment go against the principles of natural justice? Are there assets in the jurisdiction to enable the court to actually make an order to enforce the judgment? These are the considerations, at least in Canada.
Felicity, what about cross-border insolvency assistance under the model law established by UNCITRAL and the EU regulation?
Yes, I still call it the ECU regulation. I don't know why. It just feels nicer that way. Insolvency cross-border is the most effective form of assistance that you can get because you can apply your own law. If you are a Commonwealth country making a request into England under Section 426 of the Insolvency Act, you can either apply your own law or English law. So, for example, Jersey companies can be put into administration in England and then subject to English administration orders. It does require you to work out where the centre of main interests is. We've discussed that earlier. There's also common law recognition. So all of these forms of statutory recognition of comity, use of letters rogatory and all the rest of it, it is very, very effective, assuming that the receiving court isn't Spain or France.
And what about U.S. cross-border assistance for foreign insolvency office holders coming to America for help in finding remedies?
So you can basically use a mechanism called a Chapter 15 petition, and a Chapter 15 petition will let an offshore entity come up and get recognition in the United States, and then you can commence bankruptcy proceedings and have, all the bankruptcy powers that a Chapter 7 or a Chapter 11 trustee would have.
And if we like our offshore clawback rules or our offshore theories of liability, under 15 is not the case. We can perhaps argue that the foreign rules governing the insolvency might be applied in the litigation in America.
Yes, that is true, yeah.
Now, last thing to mention is under MLATs, I know Felicity, I think quite correctly, suggests they're like the F word, to stay away from them. But I think it depends on who the client might be. The World Bank had me in Cairo, Egypt recently to give talks to their anti-corruption folks dealing with their rather large public corruption issues with respect to the former regime there. And I can assure you that when you're representing a state that's been victimized by a kleptocracy, the combination between the intelligence that can be obtained by a state from other states under the Egmont Group guidelines, where they have in the U.S. Treasury set up in the United States, a secured computer system where Egypt can issue a request for intelligence of who's behind an array of 27 BVI companies through this Egmont Group. And within about a month or so, BVI will react. BVI receives 550 Egmont Group requests a year for intelligence of UBL information regarding BVI companies, and only 25 MLAT requests that are executed a year in the BVI. MLATs are far more technical and far more complex, with suppression fire and litigation going on against transmission of evidence. MLATs are for the end of the process. The Egmont Group, though, is used to gather intelligence regarding assets and the holding of assets worldwide in these massive kleptocracy cases where some of my friends, Enrico Manfrini and Yves Klein, for instance, use this technique inside of writing the MLATs for the client state, in this case Nigeria, to recover $1 billion against the heirs of Abacha. So that's a whole different sphere, but you can see the application of some of these tools are different depending on who the client might be. I'd invite anyone to ask questions of the panel. Do we have any questions? Yes, sir. You're asking a question specific to Cayman Island case law as to whether in a hedge fund context, if there's a manager, which is a Cayman company, the director of the fund, the director of the manager of the fund, yeah. Yeah. Well, it's not really Cayman case law that provides the protection. It's in the memorandum or articles of association of the fund would probably include broad indemnities in favor of directors, saying that should the director attract some form of liability while in office, the company will indemnify him for any loss. Now, there's a big controversy about that, which is called the circular concept of indemnity. So, for instance, what if the director, steals money from the company? Does it make sense that he be indemnified so that he gets sued and then he can counterclaim for the value of the liability by saying, well, look, I may have stolen some money, but you have to indemnify me for that which I stole from you. I think it's a shocking abuse of corporate governance principles, and it might be a nice idea if the Cayman legislature took a serious look at this. Now, in Anguilla, for instance, where I'm doing an insolvency case there, with some Anguillan insurance companies that failed, and $80 million of investors' money has gone missing, the statute is entirely the opposite. It sensibly says, no matter what, the Anguillan company has no power to indemnify directors or agents for anything beyond third-party negligence-type claims. So if you get in your car and drive across the town while in office and negligently hit someone else, then you may get indemnity. That's okay. But not if you steal money from the company. Felicity?
Yeah, again, there was a panel on this very subject of indemnities yesterday. Indemnities are a complete nightmare if you're trying to litigate in those jurisdictions. And I agree, it seems wholly counterintuitive. But the only thing I would say is that there may be a way out of it. I know there is one Cayman case where the Cayman liquidator is suing in the US, so that the question about the indemnity, which is governed by Cayman law, will actually be determined by the US court, who it might be thought might be less sympathetic to Cayman indemnities. I don't want to say too much more about that on the basis that my clients are some of the people being sued.
Are there any other questions? Well, with that, we'll conclude today's panel session and invite you to go to lunch. Thank you.